Hello dear students, this video is my 12th video for the subject business law. In my previous video, I have clearly explained the essential elements or legal rules relating to acceptance. To have a better understanding of the contents of this video, I will advise you to watch my previous video for which I'll give you the link in the description. Today, I'm going to begin with the chapter consideration and I'll be explaining about the essential elements of a valid consideration. So let me proceed with the meaning of consideration now. Consideration literally means something in return. To form a valid contract, consideration is very essential. It is one of the important essential elements of a valid contract. Law says no consideration, no contract, which means if there is no consideration, no contract can come into existence. So, a contract can be regarded as a valid one only if there is consideration. So, what does it mean? As I already told you, consideration means something in return. So whenever you write the meaning for the word consideration, you have to make a mention of quid pro quo. So what is quid pro quo? Quid pro quo, it is a Latin phrase. It is a Latin phrase which means something for something. In other words, it is a Latin phrase which indicates something in return. Okay? So, this is what is the basic meaning for the word consideration. So, in case if a person is promising to do something to the other person without receiving anything in return, that will not give rise to a valid contract. Okay? So, consideration is one of the essential elements of a valid contract. So, as I told you already, to form a valid contract, each party should give something and get something in return. Let me make you to understand this by giving a very simple example. Let us imagine that A agrees to sell a bicycle to B for rupees 5,000. A agrees to sell a bicycle to B for rupees 5,000. Now, B will be receiving the bicycle, which will be the consideration for him, and A will be receiving rupees 5,000, and that will be the consideration for A. So, each party is giving something and getting something in return. So, this will result in a valid contract. I hope you are clear with the meaning of consideration. Now, let me proceed with the definition. It is section 2 subsection D of the Indian Contract Act 1872 which defines the term consideration. The definition is as follows. As you all know, whenever you are asked to give a definition, you have to write it as it is given by law, and you cannot change any word or any sentence in it. So all definitions you have to memorize and by heart. Okay. So let me just read out the definition which is available here for the term consideration. Section 2 subsection D says, when at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstain from doing something, such act, abstinence or promise is called as consideration for the promise. So this is what is the definition we have as section 2 subsection D of the Indian Contract Act 1872 for the word consideration. So when you analyze this definition, you can clearly understand that consideration may be past, present or future because it is given when at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstain from doing. So consideration may be past, present or future. And it is again given that such act, abstinence or promise. So this indicates that consideration may be in the form of an act or abstinence, or it may be in the form of a promise also. All this I'll be explaining very clearly when I explain the legal rules relating to consideration or the essential elements of valid consideration. So now let me proceed with the legal rules relating to consideration, which you can also call as the essential elements of valid consideration. So let us see the legal rules or essential elements one after the other. The first essential element or legal rule we have is it must move at the desire of the promisor. It here refers to consideration. So consideration must move at the desire of the promisor. So what do you mean by this? Consideration must move at the desire of the promisor. The promisor has to willingly give the consideration. Okay? He should have the interest and wish to give the consideration. Nobody can force the promisor to give the consideration. Okay? So the consideration must move at the desire of the promisor. The one who makes the promise is called as the promisor, is it not? So consideration must move at the desire of the promisor. Here we have a very important landmark case. So whenever you write this particular point, you have to make a mention about this case and you have to explain it. So the case law we have here is Durga Prasad versus Baldeo. Durga Prasad versus Baldeo. Let me tell you what happened in this particular case. Durga Prasad is a contractor, okay? The contractor, Durga Prasad, is requesting the district collector to build a market for the local vendors or sellers, okay? Durga Prasad is requesting the district collector to build a market for the local vendors and sellers. Baldeo is a shopkeeper, okay? Baldeo, he is promising Durga Prasad that if the market is built, he will be giving Durga Prasad a commission of 5% on his turnover. Okay? So if the market is built, what is Baldeo saying? He is saying that he'll be giving 5% commission on his turnover to Durga Prasad. Okay? Later on, after the market was built, Baldeo is refusing to pay this commission to Durga Prasad. He says he will not pay the commission of 5% on the turnover. Now, Durga Prasad is taking this matter to court. Okay? But will this agreement between Durga Prasad and Baldeo result in a valid agreement? Will it be a valid one? If you ask this question, the answer is no. It's not a valid agreement. It will not result in a proper contract because law says consideration must move at the desire of the promisor. Okay? Here, Baldeo is not willing to pay it. Right? You can't compel him to make the payment. So, court gave the judgment that that Baldeo is not bound to make payment to Durga Prasad. So, this is what is the case law we have. Durga Prasad versus Baldeo. So, the first legal rule is that consideration must move at the desire of the promisor. Now, let me proceed with the second one. The second essential element or legal rule. Consideration may move from the promisee or any other person. So, to call a contract as a valid one, to regard a contract as a valid one, what is required is only consideration. There should be something in return. Who gives the consideration? That doesn't matter at all. Okay? So, the consideration may move from any person. Okay? It may move from the promisee or it may move from any other person, which means consideration may move even from a stranger. As long as there is consideration, the contract is a valid one. So it is immaterial from whom it is moving. Okay? So the consideration may move either from the promisee or from any other person. It may be even from a stranger who is in no way directly connected with the contract. But if there is consideration, that is enough. Then the contract will become a valid one. So this is what is the second legal rule we have. Consideration may move from the promisee or any other person. Then the third legal rule we have is consideration may be an act, an abstinence or a return promise. Consideration may be an act, an abstinence, or a written promise. When I gave you the definition for the term consideration according to section section 2, subsection D, when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstain from doing, that only represents consideration may be an act, abstinence, or a written promise. The definition continues further. No, you can just go through the definition. In the definition itself, there is a mention that consideration may be an act, an abstinence, or a written promise. Okay. Let me give you some examples. Consideration may be in the form of an act. So, which means it may be in an affirmative. It may be in an affirmative or positive form. Which mean, what do you mean by this? It may be an affirmative or positive form, doing something. Okay. Let me give you a very simple example. A agrees to teach accountancy for B if he pays rupees 2000. A agrees to teach accountancy for B if B pays him 2000. So this is an act. What is happening? A is going to do something. What is that? He is going to teach accountancy. So doing an act, it is a consideration. Okay. The second one is, it may be an abstinence. Consideration may be an act. An abstinence. Abstinence means not doing something. Okay. Consideration may be not doing something. So it may be in a negative also. Consideration may be in a positive form or it may be in a negative form. Let me give you an example here. A promises that he will not file a case against B if B pays him 5,000 rupees. A promises that he will not file a case against B if B gives him 5,000 rupees. Here what is happening? The other person is not going to file a case, not doing something. So where the consideration happens to be negative. So consideration may be an act, it may be an abstinence, or it may be a written promise. So again, for written promise, I can say that A sells his bicycle to B for rupees 5,000. A sells his bicycle to B for rupees 5,000. So A's promise to sell the bicycle is a consideration for B's promise to give rupees 5,000. So there is a return promise. Okay. So consideration may be an act, or it may be an abstinence, or it may be a written promise. So this becomes a part of the definition itself. You can go through the definition later. Okay. Now let me proceed with the next point. The fourth legal rule relating to consideration. Consideration may be past, present, or future. Consideration may be past, present, or future. Okay. There should be consideration only, that is required. It may be past, or it may be present, or it may be future. I'll give you an example for this past consideration. Let us imagine that for past consideration, let us imagine that A asks B to do some work. Okay. A is asking B to do some work for which he promises to pay in future. For which he promises to pay in future. I'll tell you once again. A asks B to do some work for which he promises to pay in future. So B has done the work already. Okay. So consideration is over there. So it is past consideration. Now consideration may be present consideration also. When things are done simultaneously, it is present consideration. When A sells a bicycle to B for 2,000 and gets rupees 2000 in return, there the consideration is present consideration. Okay. So it may be either past consideration or it may be present consideration. Present consideration is also called as executed consideration because it is executed, it is already performed. Okay. Present consideration or executed consideration. And consideration may be future consideration or it may be executory consideration. So I'll give you an example for this future consideration. A person by name A is asking B to do some work for him after 10 days. Okay. A is asking B to do some work for him after 10 days. So after 10 days means it's going to come in future only. Okay. For which he says he will make payment after 20 days. He is asking him to do work after 10 days, for which he says he will make the payment after 20 days. All these are going to happen in future only, where consideration becomes future consideration. So consideration may be either past, present, or it may be future also. This again is represented by the sentences which are given in the definition as per section 2 subsection D. So till now I have given you 4 legal rules as to consideration. The first one is consideration must move at the desire of the promiser. Here you have to explain the case Durga Prasad, this is Baldeo. Then the second one is consideration may move from the promisee or any other person who may even be a stranger who is in no way directly connected with the contract. The third one is it may be an act, an abstinence or a return promise. Then the fourth one is consideration may be past, present or future. So let me proceed with the fifth point now. The fifth legal rule is that consideration need not be adequate. So what is the fifth point we have here? Consideration need not be adequate. Okay. As long as there is consideration, it is more than enough. Law says that there should be consideration, that's all. Okay. This something in return need not be equal to the something given actually. Okay. So if there is consideration, it is enough. The consideration need not be adequate. I'll give you an example here. Let us imagine that A agrees, a person by name A agrees to sell his car to B for rupees 10,000. A agrees to sell his car to B for 10,000 and B is willing to buy the car. Okay. Here, this consideration, though it is not adequate, will be regarded as a valid consideration and a valid contract will come into existence because A himself is agreeing to sell his car to B for 10,000 rupees. A is okay with 10,000 rupees. He is happy with 10,000 rupees. Nobody is compelling him to sell it for 10,000. He himself is willing to sell the car to B for 10,000. Okay. So there is consideration, that's all. Right? Even if it is not adequate, it doesn't matter at all. So consideration need not be adequate. If consideration is present, that is enough to create a valid contract. So that is actually point number 5. Now the sixth legal rule or essential element is that consideration must be real and not illusory. So it must be real, it must be something which can happen, okay? It must be something which is real and it should not be something which is imaginary, which is unreal or which cannot happen or something of that sort, okay? So consideration must be real and not illusory. Consideration should not be something which is physically impossible. It should not be something which is legally impossible and it should not be something which is uncertain, and consideration should not be something which is illusory. So let me make you understand these 4 points by giving you some simple examples. So consideration should not be something which is physically impossible. Let me give you an example for this physical impossibility. Let us assume that A's wife has died. Okay, Mr. A's wife has died. A person by name B promises to give life into A's wife if he gives him 50,000 rupees. Can this happen? This is something which is physically impossible. Okay, nobody can bring back the life of a person who is already died. So here the promise made by the other person is a false promise. Okay, this is something which is physically impossible. So this consideration will not be regarded as a valid consideration. Now let me give you an example for legal impossibility. Let us assume that a person by name A owes rupees 1 lakh to B. Okay, A owes rupees 1 lakh to B. A has to give 1 lakh rupees to B. Let us imagine that B has got a servant by name C. What is the name of the servant? The name of the servant is C. A promises to pay the servant 5,000 rupees. Okay, to pay C the servant 5,000 rupees, who in turn promises to discharge A from his debt. Can this happen? Is it legally possible? Who is the servant to discharge A from the debt? He can't do it. Is it not? So there is legal impossibility here. So this consideration again is not a valid consideration. Then consideration should not be something which is uncertain. I'll give you a simple example for uncertain consideration. A is asking B to do some work for him, and he says that he will pay a reasonable amount. He will pay a reasonable amount. A is asking B to do some work for him, and he says that I'll pay you a reasonable amount. So what is reasonable? How can you decide about the reasonable amount? There is no clarity, there is no certainty, isn't it? So this again is uncertain consideration, so it will not result in a valid contract. And there should not be illusory consideration. Something which is not real, which cannot happen, is illusory. Okay? So A promises to pay 10,000 rupees to B, who promises to bring down a star from the sky. What is the promise he is giving? B is promising to bring down a star from the sky, for which A is promising to give some amount. Can this happen? This again is something which is illusory, which can never happen. So this consideration again is not a valid consideration. So the point here is consideration must be real, and it should not be illusory. It should not be something which is physically impossible, legally impossible, uncertain and illusory. That is actually point number 6. Now let me proceed with the legal rule 7, the essential element 7. It must be, consideration must be something which the promiser is not already bound to do. By the nature of the profession, certain duties people are required to perform, right? Those are the duties of the person concerned. So what is stated is, it must be something, consideration must be something which is other than that. It must be something which the promiser is not already bound to do. Here you have a very important case, Ramachandra Chintaman versus Kalu Raju. Ramachandra Chintaman versus Kalu Raju. I'll just tell you the facts of the case here. In this particular case, there was a promise to pay the lawyer an additional amount if he wins the case. What is the fact here? The fact of the case is that there was a promise to pay the lawyer an additional amount, an extra amount, an additional amount if he wins the case. Actually, the lawyer is already under a pre-existing contractual obligation to do his best, isn't it? From his point of view, he has to win the case. That is the duty of the lawyer. So, paying an additional amount, no, it is something which the promiser is already bound to do. Okay, for which you need not pay an additional amount. He has to win the case. It is his duty. The nature of his profession is that he has to argue to the best of his abilities to win the case, right? So, consideration must be something which promiser is not already bound to do. So, make a mention of the case Ramachandra Chintaman versus Kalu Raju. and explain that when you write this particular point. And the last point we have here is that consideration must not be illegal or immoral. Okay. Consideration should be lawful consideration. It should be something which is legally acceptable. It should be in a legally acceptable form. It should not be something which is illegal and immoral. To give you an example, if Mr. X is telling Mr. Y, I'll give you 50,000 rupees if you kill a person. Okay? This is an offense, isn't it? This should not be done. Okay? So it is an illegal one. So this cannot be a valid consideration. Just an example I gave you there. So consideration must not be illegal and immoral. Okay? So till now I have given you 8 legal rules as to consideration, which can also be called as the essential elements of a valid consideration. As I told you already, law says if there is no consideration, there cannot be a contract. So consideration happens to be a very, very important element of a valid contract. In a Latin term, or as per the Latin phrase, it is called as quid pro quo, and the literal meaning we have for this is something in return. Okay, so I have already given you the definition of the term consideration as given by section 2 subsection D of the Indian Contract Act 1872. Please try to memorize the definition, because very often in the examination you will be asked to define consideration. Okay, whenever you are asked to write about the legal rules relating to consideration or essential elements of valid consideration, don't give your answer starting from point number 1 straight away. First write what is consideration, write its meaning, then give the definition, and then proceed with the legal rules, which will enable you to score marks better. Okay. I hope, dear students, you are clear with all the points which I have given in today's class. If you like this video, subscribe to my channel and pass it on to your friends also. Please give your comments and your requirements so that I can post videos in future according to your needs and expectations. Thank you, dear students, for watching this video.